Right. And the second question is, we were discussing how RSD can be conducted or by whom. What about questioning the concept of RSD itself? Because it's very hard to apply it in practice. Thank you.
So the second question is the question I wanted you to ask, so that's great. So can I answer those questions one by one, or should I take? Let's take all of them.
Yeah. We have a hand in the back.
Yeah, I am Abdulaziz Muhammad Abdullah. Yeah, thank you for this opportunity. As you mentioned about the responsibility of the Egyptian government, I want to tell you something that it's happening for the Sudanese refugees who has been fled to by the Egyptian border. He has been concluded by the government of Egyptian, but I never heard for anybody in other country. But my question is, what is the situation for these refugees has been concluded by the government?
Okay. So just so I could understand your question, you're saying that some refugees are stuck at the border, they're not being let in?
Yeah, he tried to go on a country, to cross the border, and he has been arrested by the government of Egyptian. So the government of Egyptian arrested him and concluded him to his country, turning back for his country in Sudan.
So he was fleeing Egypt into another country and was arrested and returned to Egypt, or coming from Sudan or Libya trying to enter Egypt?
No, he tried to flee the Egyptian border, but he got by the government of Egyptian, and then he returned back to their home. This is my question. What is the situation about these refugees?
Okay.
All right, so Tarek, do you want to answer those two, and then we'll take another round?
So I'll start with the third question, and then the second, and then the first. Now the issue of the border is a very interesting question, and it depends on how you look at it. Obviously, if you're the state, the first reaction that you will get as the state when you hear the word border is national security. Now, there are certain situations where if a refugee poses a threat to national security, that person can be deported. Now, under the convention. Now, what will protect this refugee is actually not the convention, but it's other human rights treaties, such as the Convention Against Torture, for example. So if that person poses a threat to Egypt and will be deported to a country where he can face torture or she can face torture, then the Egyptian government is under the international obligation not to deport him to that country. However, we still have to establish that that person actually poses a threat to Egypt. We know very well that the majority, if not all refugees who try to cross the border into another country, they do it because they would like to find a better life, simply because they cannot integrate in Egypt. So that's the first argument against that person constituting any threat to Egypt. The second thing is that if you actually look at Egyptian legislation, the laws in Egypt relating to entry and exit from Egypt, people who actually enter or exit illegally are subject to potentially imprisonment for up to 1 year. If a person is a threat to security, that person will not be sentenced to 1 year. A 1-year sentence does not reflect a serious crime under Egyptian law. So my answer to you is, if a person is arrested at the border trying to flee Egypt and go into another country, that person should definitely not be deported under any international or even domestic law. So that's the first issue. If that person is prevented from entering Egypt, now that's a very clear violation of the OAU Convention. Now it's different. Under the 51 Convention, it's debatable. We can debate it forever. Technically, the non-refoulement obligation applies or is triggered once a person crosses the border into Egypt, and or into the host country. And that is found, the reason why I'm saying that is that this is what the commentary to the 1951 Convention suggests. Refoulement is only triggered once a person crosses the border, and I actually have here a reference to the exact article. Article 33(1) of the Refugee Convention speaks about expelling people. So to be expelled, you have to enter the place. The OAU Convention actually says something different. It says that no person shall be rejected at the frontier. So if a person is entering Egypt and the government says, I want to claim asylum, and is prevented from coming into the country, that is a violation of the OAU Convention. So that's an answer to, I hope that answers your question. As far as question RSD can be conducted by UNHCR in Egypt, it's very difficult to be a judge and protector at the same time. So my answer is no, I don't think UNHCR should be conducting RSD if the country has the tools. And I'm telling you what I wanted to speak about. In 1984, the President of the Republic passed a decree creating an RSD unit within the Ministry of Foreign Affairs. To this day, this unit has not worked on RSD matters. Secondly, 2 weeks later, the Minister of Foreign Affairs in 1984 issued a decree. I have the decrees in Arabic. I could give you the number, and you can find it, or you can take a copy of it. Issued another decree creating the RSD unit, basically explicitly nominating the person who would head that unit. That person sadly passed away about a year ago, and declaring that this unit's decision relating to RSD is not subject to appeal. So there are tools. We've had them for 31 years, never been used. And my contention is if UNHCR wakes up one morning and stops doing RSD, there might be on the short term, it will be disastrous, but at some point, the government will have to activate the tools that already exist. Regarding the right to resettlement, that's actually a controversial issue, and you would have to look at the purpose of the convention. What is really the purpose of the convention? Is the purpose of the convention to protect people from being deported to a country where they could face danger or persecution? Or is it a general human rights instrument that could allow people to be resettled and seek a better life elsewhere? Now, depending on which side of the table you're sitting, you can argue both ways. My opinion is if resettlement is already mentioned in a convention, then it's an argument in favor of it being a right. However, there's always the counter-argument, which is what about locals? What about locals who are not living in the best of conditions, who live in shanty towns around Cairo? Why can't they have that right, and refugees do? So you can never satisfy anyone on this question, and it depends which argument you're trying to advance. That's my answer to it.
Okay, so I actually have things to ask after that answer, but again, I will, hold it in on behalf of all of you. Does anyone else want to? Yes.
Hello, my name is Marwan. Tariq, thank you for the presentation. My question is related to the Egypt capacity of conducting RSD. So, do you think that having the unit created in 1984 does necessarily mean that Egypt does have the capacity to conduct RSD? And in a very general sense, could you please shed some light on what do you think the tools that Egypt has to conduct RSD? Thank you.
One more. There's one over there.
Thank you for the presentation. During this time, 2003 and 2010, there are many refugees. They fled from Egypt to Israel and to other countries, and also some of them they are still, they're still here in Egypt till now. I want you to talk more about the situation of the refugees at that time, why they are fleeing, they are going to other countries, and some of them why they are still here. I wanted to tell us, because you was working here at that time, to tell us to give us your opinion about this. About the situation of refugees there, and also what about the facilities and services that they were taking at that time from the government of Egypt or the other organizations? Thank you.
One more if we... No? Okay, so Tarek, do you want to...
Okay, so regarding the capacity to conduct RSD, we have to agree that RSD is a legal exercise. So I do think that if you have legal training, I don't want to say you're more qualified than if you don't have that kind of training, because you're dealing with people's lives. And when you deal with people's lives, by applying the law, you need to know how to apply law. That's the first question. And obviously, you need to have some compassion and humanity. But at the end of the day, it is a legal exercise. And there is no shortage of judges and retired judges in Egypt. The actual decree relating to the creation of the committee specifically mentions that the committee will consist of a representative, among others, a representative of the Ministry of Justice, who's most likely a very senior judge. So there's nothing wrong with making it a gradual process. Obviously, you cannot have the tools overnight. It can take at least 5 years. You can plan it over 5 years. By training judges, we have very qualified UNHCR staff in Egypt and other countries. They can be involved in training those judges. And there was training for judges, I remember in 2005, which I attended. That was organized by FMRS at the time. So it is a gradual process. And you can do it without excluding UNHCR. I mean, one of the things I'm thinking about, you can have UNHCR do the first instance, and then after that, if a person is accepted, that person can take the blue card. But if the person's application is not successful, that person, or is denied, that person can appeal the decision to that committee after after undergoing training. Now, the benefit of this is that it will resolve one of the biggest issues in RSD, which is the existence, or non-existence rather, of an appeal system, an independent appeal system. So maybe that's a thought, and we can discuss this later today or any other time. So that's the first question. Regarding what facilities and services, I don't want to say none. There were services provided by different organizations, including Caritas, good intentions, no resources. So that's a very short answer. I remember at Amira, we used to work with doctors who would operate on refugees free. I don't know if this option is still available in 2015, but as far back as 2007, when I left Amira, it was there, but it wasn't enough. So that's the answer. Regarding people who go to Israel, it's important to distinguish between people who are trafficked and people who go voluntarily. Egypt has a trafficking law, which it passed recently, I believe 3 or 4 years ago. I can't remember the exact date. Which explicitly says that people who are trafficked are protected from deportation and are not subject to any criminal penalties in Egypt. So if people are trafficked, there are the legal tools that can protect them from detention and deportation. It's more difficult for people who are smuggled or who voluntarily go to Israel, because technically they do breach Egyptian law. But as I said earlier, the penalty, and that usually it was, when it was designed, it wasn't for refugees, it was for people who did not face persecution. It's a maximum of 1 year arrest. You're telling me people have been detained for 5 years. This is unacceptable.
All right, so I'm going to ask you a couple of questions, Tarek.
I don't feel comfortable about this.
No, they're nice questions, don't worry. They'll allow you to do the rest of your presentation. I should actually mention before I get to my questions that on the trafficking issue, although the law is there and it's actually quite a good law on paper, the way it's being implemented currently, at least, is it's very much focusing on Egyptians who are being trafficked. So unfortunately, it's not that helpful to what we're talking about today, which is refugees who are transiting through Egypt and are getting caught up in trafficking, either of people or organs or whatever, because we know that there's all kinds of networks going through that path. But okay, so my question is what you mentioned earlier: what is the purpose of the Refugee Convention? If we try and figure that out by looking at the preamble of the convention, the travaux préparatoires, the actual contents of the convention, we know that it was written not as a convention for a few countries, but as a convention that was supposed to be as global in reach as it could be, because it was supposed to be about international cooperation for asylum, for the right to seek asylum. So I feel that the reason why UNHCR is serving this purpose, this function in various developing states, is because developing states host almost all the refugees in the world. Almost all, yeah? So despite Europe freaking out about people crossing the Mediterranean, everyone is still in the developing world. So one way that developing states say, well, if you really mean to share the burden, then at least through your funding of UNHCR that then serves this function, then some of the burden is being shared because we're doing almost all the other work. So it's basically talking about the politics of what you're proposing, not that Egypt is not capable, but, you know, then maybe there should be some other form of burden sharing through resettlement or something else to offset that, because that's why developing states are so reluctant to spend anything on training or developing their ministries to do these functions. You know, even when they actually have a setup, they don't develop it for, you know, more than a decade. So that's the first thing. The second thing is more along the lines of the first question that was asked, is it really possible to do RSDs properly anyway, no matter who does them? Well, there we have two things going on. Egypt has signed the convention. Egypt has said it's going to fulfill all its obligations in the convention. So we could say, as Tariq's saying, well, then why don't they when they have the capability? Well, the problem there is with each country doing that, the way the convention is structured, the definition and the process is very different in each country. So in that sense, UNHCR doing it actually makes the application of the convention more universal, in that wherever they're doing it, they have their guidelines that make sure that it's relatively harmonious in all the countries in which they operate. So in that sense, it's a good thing. The bad thing is that, of course, if an international organization that's not party to a convention is implementing the convention, then the international organization is largely unaccountable and untransparent for what they're doing, as opposed to Egypt, which is a state party that can then be held accountable for breaching the convention. So I was thinking along the lines of what she was asking earlier, that, you know, in what way can this actually work? Because there are such major problems either way. So I don't expect you to find a solution to this, Tariq, but it would be great to have your thoughts on it.
Well, my thoughts on it, more specifically the issue of RSD, I'll start with the second question and move to the first one, is that I don't see a problem with states conducting RSD simply because under the UNHCR statute and the convention, UNHCR's role remains to be seen. I mean, it's there. The UNHCR is supervising the application of the convention. So if there are major flaws with RSD, there's nothing that, and I know that needs a bit of creativity, and I haven't thought a lot about it, but those who are denied, or if there are abuses in the or flaws in performing RSD, there's nothing that prevents those rejected or whose applications were rejected from still being resettled. Because at the end of the day, and those who worked in this field know that there's still resettlement on humanitarian grounds. Like, there are still people who do not meet the classical square definition of refugee who were accepted for resettlement in other countries. And at the end of the day, it is the decision of the resettlement state. So if we're talking about burden sharing, and I will move now to resettlement, there are a lot of questions about the use of the word burden. So that's, I mean, because human beings are not a burden. That's
Yes.
the first question.
That's the
we
term
all
used,
agree
if
on that.
that's
But I know
right,
that's
yeah.
the term used, which I have serious reservations on. But there are currently some examples that are happening in Europe right now with regards to Syrians and how some countries are being bullied by others to host refugees. And I don't see why, again, in theory, and it's an idealistic approach, and it needs a bit of thinking, how this cannot be done internationally as well.
Right. Yes? He's coming.
Hi. Okay. So you said earlier in the presentation that you think that the memorandum doesn't reflect current times, but what would need to happen for the memorandum to be changed? What would the government have to do for it to actually reflect current times? And also, does that even matter? Because it sounds like it's very vague, and even with the reservations, even with the articles on which the government doesn't have reservations, the government isn't following through. So I guess my question is, what would have to happen for the memorandum to reflect times, and does it actually even matter if legally it's changed, if the realities are still the same?
Okay. So as far as does it really matter to amend it is concerned, my answer is no. I mean, just look at the convention, and these are the obligations. Everybody knows that under the convention, these are the obligations of the state. However, you still need a document that designs the relationship or identifies the relationship between Egypt as a government and UNHCR. So this is where the MOU needs to be amended. I mean, UNHCR staff, at least international ones, have certain immunities. I mean, the relationship between UNHCR as an office and its staff and the government needs to be clearly reflected. So we can amend it, but all the legal issues or issues relating to the obligations of the state could be taken out of it.
Any other questions? We have one there.
Thank you for presentation, Mr. Tari. Does the UNHCR might learn from his experience or problems, especially about African conflict? And is there an enhancement for the weakness of UNHCR in the coming future? And sometimes the UNHCR stops helplessly. Why? And we need it to be strong enough for the coming future. Thank you.
Thanks. Do you want to answer?
I was going to say, I think the best person to answer this question is someone who actually works for UNHCR or knows UNHCR. I am honestly and personally not aware of what steps are being taken at UNHCR. I don't work for UNHCR, so I don't know what the actual steps that are being taken at UNHCR to boost the resources. At the end of the day, it's donor countries and organizations that give money to UNHCR, so if it's a financial issue, and to a large extent it is, it all depends on countries that give money to UNHCR. So maybe what needs to be enhanced is the country's generosity, or UNHCR's donations department, if there's such a thing, you know, to do a better job at asking or promoting the organization. As far as the competence of UNHCR staff, well, as I said, UNHCR is a good organization. It has its flaws, but it's still a great organization. That said, training staff depends on the availability of resources, and I think it would be a good idea to start involving governments so that you can free up some of those resources to improve UNHCR. UNHCR has no enforcement powers. UNHCR cannot force the government to do any. For all that matters, the government can wake up one morning and kick out every UNHCR staff members from the country, and nothing will happen. That's the sad reality. Some shaming in the media, and that's it. So UNHCR has no power to force governments to do anything. It can supervise, and it relies on governments' good intentions. That's it.
Any other hands? Mesa?
One of the problems of the MOU is the Article A and B regarding that does not mention local integration at all. And I know that you also said that legally the states should allow for local integration, and none of the reservations are actually preventing local integration. But that's legally. But the reality is that it's because, okay, there is no reservation on employment, but they still have to get a work permit. There is no reservation on health services and education, but they cannot attend schools and public hospitals. So, just a comment.
But that's I completely agree with you. My comment was more about what the law says. And in practice, it's obviously a different case. But in that case, it's a breach of the convention by the government. So when you agree to applying certain or to abiding by certain obligations, and then you go from the back door, basically imposing obstacles to the imposition, to the application of the terms of the convention, then as a country you are held in breach. I mean, you are breaching the convention. As far as the right to education and certain rights, and I'm glad you mentioned education in particular, because this issue hasn't changed since 2003, but the reality is there are many laws and decrees in Egypt that specifically dealing with education, that specifically say that everyone in Egypt, regardless of status, or children in Egypt, regardless of status, have the right to education. There is a children's law which overrid the earlier child law that actually specifically spoke about Egyptian citizens. The new law does not discriminate among children on the basis of nationality. That specifically says that it's a right, that they do have the right to access public schools. And then there is the 1992 decree that we all know about that lists certain citizens of certain countries which cover actually the majority of refugees that are entitled to go to school. So if the school administration prevents children from accessing those schools, then it's a violation of the law. And no.
Okay, so to follow up, I was actually going to ask the same thing, so thanks, Mesa. But now I'll instead ask you, because you talked about as you said, the mandate of UNHCR has evolved. So mentioning that in the MOU means that if we interpret it as a living document, then we interpret it as the mandate of UNHCR evolves to include particular social group. But it's evolved well beyond that. UNHCR probably has the biggest, most expanding mandate of any international organization, and it's going to keep expanding. So then we can see the problems if we look at the sit-in that you talked about, the difficulties if the state is not intimately cooperating with UNHCR, the state is not communicating well with its population, the problems that can arise. And this is the worst case scenario, the example that Tarek gave us, but there are problems, to a greater and lesser degree along those lines. But what I'm wondering is this necessarily going to be solved by the state taking over those responsibilities? Because is the problem with the state communicating with this sector of its population to do with the fact that UNHCR is dealing with them, or is it something else? Is it that this is simply not a priority issue in Egypt, that in fact in many developing states, as you say, social welfare is so difficult for local populations that it just does not seem feasible to expect the state to then provide this for those who are not their immediate citizens, that that it's a bigger political economic problem. Again, it's you're right, we shouldn't call it burden sharing, and I tend to call it responsibility, but the legal term unfortunately is burden sharing. The convention was written a long time ago. But again, it comes down to that. I mean, then perhaps people should ask for resettlement and should get resettlement, because while we can say that perhaps an Egyptian that doesn't have these welfare provisions should also be resettled, well, we don't have a treaty for that yet, but we have a treaty for this. And I wouldn't blame a poor state for saying we're not going to provide welfare for asylum seekers because we can't provide them for our own citizens. They should have something else, which is perhaps a right to resettlement, which someone said earlier. I don't know, what do you think?
I think it's very difficult to separate law from practice, and it's very difficult to separate law from economics. Right. And the reality is, Egypt is a developing country. It is poor. That's on one hand. On the other hand, it has a huge governmental infrastructure which can be utilized to serve a good purpose. So I don't know how many million government officials we have in Egypt that can be trained, and instead of having 2 million people in certain ministry, we can take 500,000 and put them in another ministry, and actually the ministry that will lose the employees will probably operate better. And then you will have, so we can, there could be, some shifting can be done internally. I'm not saying anyone should be fired. I'm saying they can be trained and used for a good purpose. So we do have an infrastructure that could be developed. That's one thing. The other thing, if you look across the border, you look at Lebanon and Jordan, and they're dealing with many more refugees, and they're not very rich countries, and they're still surviving. So the whole argument of we are a poor country, we don't want to work with refugees, I find it unconvincing, to be honest. The issue of treaties and how to use law. In 2004, so 11 years ago, a treaty between Egypt and Sudan came into force, the Four Freedoms Agreement. That agreement gives, again in theory, Sudanese nationals the right to live in Egypt without a visa, the right to work without a permit, the right to own property, and the right to cross the border. Obviously you have to have a passport, but the right to enter Egypt without a visa. So this agreement has been in existence for 11 years. It is not applied. The reason why it's not applied is because nobody's asking for it to be applied. And the only time I remember it was applied was after the sit-in. The demonstrators were taken to detention centers. There was the intention to deport them. And if it wasn't for UNHCR's insistence that there was a treaty that protected them, that allowed them to stay in Egypt, that they wouldn't have been released, or they would have been deported. So it was used before. It's just that you need a bit of pushing for it to happen. Sadly, there aren't that many organizations that provide legal aid anymore. There used to be some in the past. They don't exist anymore, but it's due to these organizations that you can, or because of these organizations, you can get things moving a little bit.
Yes, we have.
Hi, my name is Ragnhild. I work for UNHCR. I would like to ask you to highlight very briefly if there were any shifts or your main points that you would wish to highlight from the period when you worked here.
I'm sorry, did you say shifts as in things changed?
Yes.
In policy? Yeah, well, the interesting things that happened, as I said, were not necessarily UNHCR related. They were related to global politics or politics in the region. What I found interesting, speaking of UNHCR, was UNHCR's creativity or ability to change its policies in a way to deal with those situations. And I'll mention one example. I have another one, but I have two examples. Maybe you can discuss the second one involving Iraqis after the presentation, because I can go on for hours. But the one I'm thinking about is in 2004 when the Four Freedoms Agreement was signed, and UNHCR and the peace agreement between the government of Sudan and the SPLA at the time. UNHCR decided to suspend RSD activities for Sudanese refugees and granted them temporary protection. And I think that lasted for 2 years. Maybe it lasted longer. I had left by then. But I thought that was a creative way to address a problem. It wasn't the ideal way, because what happened as a result was the issue I mentioned earlier, is that many of those refugees who took yellow cards had no idea what their status was. They thought they were, they had the refugee status or could one day be resettled, but everybody knows, at least practitioners, that temporary protection doesn't give you the right to resettlement, and it's actually not refugee status. It is a humanitarian approach or a creative way to address situations of mass influx. But so the intention was good. It's just there was no communication, and that was a problem, I thought.
Your second, you had two.
The second one involved Iraqi applicants, and that one was very interesting because UNHCR at the time wanted to apply the OAU Convention to Iraqis, and there was serious opposition on the part of the Egyptian government. The main argument used by the government was that the OAU Convention only applies to Africans. Now that's a serious academic debate. I think it doesn't. I think the OAU Convention should apply to non-Africans. I have some reasons as to why it should apply to non-Africans. I mean, for example, if you look at the definition of refugee under the OAU Convention, it says every person. It doesn't say every African. That's the first one. The other issue is that if you look at the drafting history of the OAU Convention, it does not indicate any policy of exclusion towards non-Africans. And also an inclusive interpretation is in line with the purpose of the OAU Convention, which aims to counter foreign occupation and colonialism, which was a perfect example relating to Iraqis who were invaded literally in 2003. So all the conditions of the OAU Convention apply, and there's more reasons. For anecdotally also, if you look at the title of the Refugee Convention, of the OAU Convention, it says, the title is as follows, and I have it here even. Maybe not. So if you look at the definition of the title of the OAU Convention is the OAU Convention governing the specific aspects of refugee problems in Africa, not from Africa. So you become a refugee once you leave your country and go into another. So once you're in Africa, in an African state, the convention applies to you. I mean, these are all arguments. Obviously, you need something more binding than this to confirm that. But to deal with the situation, instead of fighting, UNHCR decided to grant them prima facie status, which is a more sophisticated version of temporary protection, but it still doesn't give you full rights. So I really liked at the time UNHCR's creativity, but I did think a bit of a fight should have been put. And one of the examples, perhaps UNHCR could have sought an advisory opinion from the ICJ. And there are tools for that. I mean, I can go through this if we have time, but there are tools for that. There's Article 96 of the UN Charter, Article 65 of the ICJ statute, and there was a precedent actually. The WHO had sought an advisory opinion relating to the interpretation of its agreement with the Egyptian government in 1981. So a bit of creativity, maybe a couple of lawyers hired at UNHCR could have helped a bit, but.
Thank you, Tariq. Final round of questions, anyone? Last chance. One there.
I'm sorry?
Urban.
Arab indifference?
No, urban cities.
Urban cities, sorry.
Also, in the time that just after that war, where accepting
It's an easy question.
I feel I'm having a déjà vu because I've discussed this question before, and the answer is fairly straightforward. I mean, at the end of the day, the essence of refugee protection, it is an individual exercise. You as one individual have to show that you are persecuted. The whole concept of group status is a development. It's a bit of an innovation. I'm not saying it's wrong, but it's not what the convention was drafted with the intention of covering. So there are situations where you have mass influx of refugees or emergency situations where it becomes very difficult on the state to process applications. Egypt has seen several waves. So now until recently, there were waves of Syrians. It's very difficult to process, coming into Egypt as refugees, it's very difficult to process their individual applications. Before that, there were waves of Iraqi refugees. And then before that, there were waves of refugees or influxes of refugees from Sudan. And at some point, there was a rise in the number of applicants from Darfur. So the policy that was taken by UNHCR at the time was that it's very clear that there's a war in Darfur. The international media supported that view, donors supported that view, resettlement countries expressed interest in hosting people from Darfur. But objectively speaking, it was very difficult to conduct refugee status determination, to process individual applications. So objectively, it was very clear that anyone coming from Darfur would have qualified for refugee status, more likely than not. So they got their blue cards. Situation is a bit more difficult with people from other parts of Sudan, because right around the same time, the peace agreement was signed. So sadly, if you were to apply refugee law at the time, the majority of people who came from the south of Sudan would have been refused, or their applications would have been denied. Because at the time, it's forward-looking. You fear persecution in the future. So at the time, to qualify for status, there are exceptions, but that's... So at the time, anyone who came from from the south of Sudan in particular, who claimed that was being persecuted by the central government or allies of the central government, was more likely than not going to be refused. So UNHCR granted all applicants from Sudan who were not from Darfur temporary protection, which is basically freezing the situation, but giving them yellow cards so that they can stay in Egypt for 6 months renewable until the situation in the future would become clearer. And at around the same time, the Four Freedoms Agreement was signed, which added to the confusion at UNHCR and among the population. Now, my issue with this is that communication with the refugee communities at the time was very flawed. It was very weak. And as I said earlier, everyone was responsible. But was UNHCR's policy towards people from Darfur right? I think it was. But I think communicating the situation to other Sudanese refugees was not done correctly, which caused a lot of problems after that.
Okay, thank you, Tariq, and thank you, everyone. I think you'll agree with me that there's more to talk about, and there are refreshments outside, so I encourage you to continue the conversation with each other and with Tariq, if I can volunteer you, outside. So for now, just join me in thanking him. Thanks, Tariq.
Thank you.